My name is Adrian Harrell, and I am a property manager here in Turlock. I've been a property manager for the last 14 years. I've been with Newbridge Management since 2009 when we were established. We serve San Joaquin, Stanislaus, and Merced counties, so we have a pretty large coverage, and we have offices in Modesto, Turlock, as well as Merced. We're going to talk about a couple of resources. I found these to be some of the best resources. KTS is a law firm based in Oakland, and they provide a lot of information. You don't necessarily have to be a client of theirs to get some of their published articles, and they provide a lot of information. So if you send them an email, they will send you updates, and they have some FAQs that are very helpful to landlords as well as tenants. Of course, the state legislature is always helpful. Go directly to the website for the state of California, and you can get some laws there. California Apartment Association also provides a lot of information, and Mark, Paul, and myself are always good resources. I can't tell you the number of phone calls that I get from tenants as well as landlords that are not clients of ours asking us questions regarding any particular situation. And if I'm not able to help them, I always consult Mark or Paul. So those are some of the resources for you guys. We're going to jump in, not just what's happened in the recent months. I'm going to take you guys back a few years to kind of try and understand how in the heck is it that we got here? What happened in the last few years that got us to where we are today? So I'm going to take you back to about 1970s. 1970s, a lot was happening. You will find that things were not too dissimilar as they are today. I mean, the rising prices in real estate, I mean, everybody's complaining about prices of real estate being high now. They were skyrocketing during the 1970s. Interest rates were going up. Some people were talking about paying as much as 18, 19, 20% when they were buying houses. I can't even fathom that. Today, we're thinking, oh my gosh, 4% is too high. I want to be paying 3% on an interest rate. Whereas in the 1970s, those interest rates kind of skyrocketed. Land use was limited. The state of California was dictating as to where the cities could build and how they could be built out, whether they could be single-family homes or multi-family homes, high density, low density, or if they were being specially left aside for the Williams Act, agriculture. So land use was somewhat limited. Federal government reduced the housing budget. This last year, as you all know, HUD's budget got docked by about $1.2 billion. So things are still similar. Things haven't changed too much. Inflation rates were going high. They were getting really high. Wages were stagnant. People weren't making a lot of money in the 1970s. Proposition 13 had passed. Now, some of you may know, Proposition 13 has to do with the amount of taxes that you pay on the real estate that you purchase. So that law had just recently gone into effect. And a lot of people were starting to look at the return on the investments. Individuals that were investors in real estate, they started to look at how much money am I really getting back on my investment? And then the city of Berkeley started, as the first city, started to talk about rent control, and they were the first city in the state of California that actually pushed rent control through. So a lot of that was happening in the 1970s. Moving forward, San Francisco filed suit, Oakland filed suit, not much longer, the city of Los Angeles filed suit, Santa Monica also filed. So a lot of cities, there are about 11 municipalities before today that had rent control. And during the 1990s, Jim Costa and Phil Hawkins, they said, now wait a minute, we can't have rent control on everything, because that is really going to be hindering the amount of development that happens within the state. And it had hindered development. So they passed a bill named Costa-Hawkins. You guys, that should probably sound pretty familiar to you, because in the last 2 years, they tried to repeal this act. And this law was actually signed as a law. It was AB 1164 by Pete Wilson. And what it did, it said that any property, any multifamily property that was built from 1995 onwards would be exempt from rent control. Older properties, they can have rent control. Newer properties, newer multifamily units cannot be under rent control. And that was a kind of a good thing for a lot of the developers, because they saw that, okay, if we put in a lot of investment and develop properties, now we can expect to get some sort of return on our investment, and as our costs go up when the buildings become older, we can continue to improve on these properties and not let them fall back. The law did get modified. It added more exemptions. And so in 2002, condominiums were added to the exemption. And it said that if an apartment complex is being converted into a condominium project, for those properties, because there's a lot of investment going into them, will no longer be part of rent control, because they would be considered new. And they also did a new backdate. So what they said, because some of the properties in the cities that already had rent control, they weren't allowed to be exempt from rent control. So they went back and said, okay, so in San Francisco, because rent control went into effect in 1978, any property that was built after 1978 may be exempt from rent control. And they did the same thing for Berkeley and Oakland and a lot of the other cities. So that was one of the things that Costa-Hawkins did. Now, in the last 2 years, during the last election cycle, there was a huge push by the tenants' rights advocacy groups and the AIDS Society from Los Angeles that said, you know, we don't really like that. We want to have this law repealed. I can say that it didn't get repealed, but where we are today is kind of what was as a result of that not getting repealed. So you move forward from 95 to about 2015, and lately we're seeing that things are really starting to change. California is becoming one of the most prosperous states in the country. As a matter of fact, if you were to take the economy of the state of California and you were to put it against other countries, we are now the 5th largest economy in the world. I'll be honest, I was shocked by that, because I had heard 6th. I didn't realize that we had moved up to 5th largest economy in the world. So the state is overall is doing really well. We have the highest employment rate in the country, and our unemployment is about 4.8% when you're comparing the state of California with other industrial states. So our unemployment is pretty low. On the flip side, we're a prosperous state, but you know, there's also the haves and the have-nots here in the state. What's happened within the state, it's got the highest poverty rate in the nation. 1 in families, 15% of the families actually suffer in poverty. Surprisingly enough, I'm gonna ask you guys, a family of 4 that lives in the Bay Area, what is considered poverty?
107,000.
Thank you. If a family is making $107,000 and they are living in the Bay Area, they are officially living at poverty level. So 1 in families is not that surprising. The subsidized health care, 1 in 3 families get their health care from Medi-Cal. And 36 rural counties have the highest unemployment rate. They have at 6.6%. So when you look at rural counties and more of the agricultural counties versus some of the coastal counties, you see that our unemployment is relatively high compared to the rest of the state. So when you are taking into account housing, California actually has the highest poverty in the nation. The interesting thing is that we now have lower ownership than we did in 1940. So ownership is actually steadily declining within the state. 84% of the renters in the state of California are considered burdened. That means that either a third or up to 50% of their annual income is actually going to pay for their housing. Now, as a property manager, I will tell you that we require that someone be making 3 times the rent as income. That happens, and there are people that are just barely squeaking by to try and make 3 times the rent. So they are technically considered burdened by the Department of Housing and Community Development here in the state. This is just a graph. I did take a picture of this, so that's why it's a little bit crooked. But it shows that we had, in 2005, we had a little over 59% of our state were homeowners. that number has been steadily declining. It is anticipated that the state of California will become a renter state, and that number, the home ownership, will drop to about 41% of the state. So that tells you that the cost of housing is steadily going up. And everybody's wondering, well, why is that going to happen? At $440,000 average price for a home in the state of California, we're about 2.5 times the national average. The national average for a home is about $180,000. So I always say we pay for the sunshine in the state. And that's why we are the golden state. We pay for the gold. Between 2009 and 2014, I love this number, 467,000 new housing units were added. Great. We have a lot of housing, a lot of construction that in those years happened. And yet we added 544,000 new households. Now, household means either individuals that moved into the state or families that were living together and then they split up and now new households are being created. So we're not building enough to meet the current demand of our state. This was a great example that really drove it home for me. San Francisco built 20,000 new units. I love driving over the bridge, the Bay Bridge, when I go into the city because you see all these cranes, all this construction going up. 20,000 new units. Great. They added 74,000 new jobs. Now, with those 74,000 new jobs, people come. And it shows you that there's a disparity with the number of properties that are being built versus the what is actually currently in demand. Our Governor Newsom, has said, I want 3.5 million new housing units. And in 2015, a law was actually passed by Governor Brown, the previous governor, that really was starting to rely on individual homeowners. They said that we're going to allow you to build ADUs, additional dwelling unit. And that is a unit, kind of like a granny unit that can be built on the back of the house to allow for either kids to move in, in-laws to move in, or to rent it out. They were showing that 127,000 new units were actually built in 2018 throughout the state. The demand was 180,000. So when we have 180,000 annual need, those needs are not being met. And I'm not going to get into the construction costs and permit fees. I work with developers, and I hear it every day. So we know that we have a shortage. But now that we've looked at how we got to where we are in the number of properties, let's take a look at who the state of California is. Who are the Californians that live here? So right now, 46% of the state of California is renter occupied. 54% are owner occupied. That's almost at parity, which is getting pretty close. But when you look at your major metropolitan areas, you're anywhere from 50 all the way to 65%. And so when you're questioning, how did we get here? How did we get a statewide rent control law passed? Your metropolitan areas, the majority of them, are renters. And guess who goes out to vote? When it affects their pocketbook, people get out and vote. So that's kind of a demographic of what's happening within the state of California. So we think, all right, 46%, there's 54% homeowners. We'll take on the renters, right? They're not the only ones in the game. Facebook has had given out $500,000 to City of East Palo Alto to help individuals with legal assistance in either if they were being evicted or if their rent was being increased. And then the Chan Zuckerberg, they promised $40 million in funding to cities that would develop programs and technical assistance for tenants.
Is that related, Chan Zuckerberg, to, is that?
That is Mr. Zuckerberg as of
Mrs. Facebook.
Mr. and Mrs. Facebook. That's their philanthropic arm. They said they have a $40 million fund. Now, I'm gonna blow you guys away a little bit more because this one really blew me away. The Tech Equity Collaborative, their mission, it says to pass renters' rights legislation, reform Proposition 13, which is our taxes, and labor protection. Now, who are their funders? Chan Zuckerberg, Omidyar, San Francisco Foundation, Kapoor Center for Social Impact, and Microsoft. These are huge, huge corporations that are helping these guys out. Now, I didn't know who San Francisco Foundation was. I had never heard of them. I'll be honest, I didn't know who they were. They were founded in 1943. And oh, by the way, they have $1.3 billion in assets to try and better the residents of a region, and in San Francisco, the renters. And they are fighting for renters' rights. So when we're, as property managers and investors and homeowners, when we're looking at these things, we're thinking, oh, it's the landlord-tenant. Well, there are nonprofit organizations that are also in the game that are really pushing and lobbying for our representatives to do something. But they're not the only ones. This was all over the news recently. Google promised $1 billion. Apple, not to be left too far behind, they promised $2.5 billion to help the tenants and the housing shortage and the crisis in the Bay Area. So this is real money. I mean, some people think, oh, well, you know, it's just the tenants, but there is some real money that is being funneled to help tenants and residents, and everyone has the same goal. Everyone says, we have a homeless problem. We all are in it together. But some people have more help than we do. So that's why we kind of get to where we are today. So Representative Chan from San Francisco, to try and help tenants, put forward Assembly Bill 1482. And there was a lot of fighting going on to keep that off the governor's desk. I mean, there were so many different iterations that the final bill, which was 1482, also known as the Tenant Protection Act of 2019, is what ended up on Governor Newsom's desk. And on October 8th, he signed that along with a lot of other things into law. He codified them. And the 1482 covers rent control, just cause, and price gouging. And those are the three main areas that we're going to be talking about this evening. So let's talk about rent control first, and then maybe you guys will have a sigh of relief and say, okay, I'm done, I can go home now. But I'll tell you who's exempt first of all. Single family homes. If you are an individual owner and you have single family homes, you're exempt. That was iffy as well, because they were saying that if you own 10 single-family homes, which some of our clients do, you wouldn't have been exempt because now you're an investor. But thankfully, that's not the case. So if you have a single-family home, the property is exempt from rent control. Condominiums, and this kind of goes back to the law itself, because it says that individual condominium or single-family home, it can actually be separated out and on its own. So, in terms of title, that's why condominiums also fall under that. Owner-occupied duplexes. So if somebody owns a duplex and they live on one side and they rent out the other side, that property is considered exempt from rent control. Housing that is less than 15 years old, and this is a revolving 15 years old. And what I mean by that is that so we are in 2019. If the property was built in 2010, it's only 9 years old. So it will be exempt from rent control for the next 6 years. If your property was built 14 years ago, it's only exempt for 1 more year. So it's a revolving 15-year. One thing that I didn't mention, although this law was signed on October 8th, and it's going to go into effect as of January 1, 2020, technically it's supposed to sunset on January 1, 2030. the state of rent control is only supposed to be for 10 years. Reality is, I don't have a crystal ball. I don't know if it's still going to be California is still going to be a rent control state, but it could continue on. I mean, a different governor could come along and say, no, we're just going to go ahead and extend it. And that could be a possibility. That's why that 15 years is a revolving one, because if a new property is being built now, 2030, then by then the property will only be 11 years old. And if the rent control has sunsetted, then they don't have to worry about it. But after that, they'll only have 4 more years before it's going to go into rent control. So that's a revolving number. Any affordable housing is exempt from rent control. Properties that are already subject to stricter rent control. So if you have a property in the city of San Jose, Oakland, or San Francisco, Santa Monica, Los Angeles, Alameda, any cities that already have rent control that are stricter than this policy, then those would be exempt from this one because they fall under a stricter rent control policy. And by the way, if you guys have any questions, please feel free. And if I don't know the answer, I'm going to point to the gentleman and then have them answer the question. So the first thing that everyone asks, well, okay, I own a duplex. What is my cap? The cap for rent control, it's 5% plus consumer price index. It cannot exceed 10%, and it can only be an increase of every 12 months. Now, Stanislaus County does not have its own consumer price index. I will tell you guys what the consumer price index is right now for Stanislaus, Merced, and San Joaquin counties. We go off of the consumer price index in Sacramento, and it's at 3.34%. So if you're going to be doing any type of a rent increase, it cannot exceed 8.34%, okay?
And how often does that change? How often do they update it, quarterly?
The index, I believe Sacramento is quarterly, yes. Here's the beautiful part. I have just one little word that says notice. Whether your property falls under rent control or it does not, regardless, you have to notify the tenant of their rights and the fact that the property is or is not under rent control.
You have to tell them one or the other? Or
You have to tell them if the property falls under rent control, you have to tell them it falls under rent control. If it does not fall under rent control, you still have to tell them that it does not fall under rent control. And here's the deadline, January 1, 2020. You have to notify your tenants by January 1, 2020, whether the property falls under rent control or it does not.
Now, do you have to notify them when you're giving a rent increase, or do I do it at the time of the lease?
You have to notify your tenants no later than January 1, 2020, whether it is or it's not.
But now let's say 2020 comes along next year, I'm starting to write some leases. Can I put it into my lease? And by the way, and then I'm done with them.
Yes.
From that point on.
So the existing tenants, you have to give them an addendum. And then in your new leases, so you have somebody move in February 1, 2020, that language has to be part of your lease, and it cannot be any smaller than a 12-point font. So it has to be big and bold so that they can't say, oh, I didn't see it.
So you just do it as an amendment to your car form.
Yes.
You use Helvetica or Times New Roman?
I don't know the font that you have to use. I will tell you, I use Arial on my font because it is very clean, it's simple, it doesn't get too fancy. So, and then if you...
By what date?
January 1, 2020, you have to notify your tenants. So you have about 1 month and 16 days.
And emailing them is legal notice now, correct, or no?
If you already have in place a policy that the tenant signed in the beginning, or that you notify them that this is our mode of communication with you, email works. But if you've not done that, then you have to send it to them.
And does that be registered, or can you send out general mail?
First class.
First class mail.
And I would err on the side of make one letter, photocopy it, and put it in a stamped envelope to each and every tenant. I mean, for 55 cents, you're getting that little extra bit of assurance that when challenged, you can say, I notified each and every one of my tenants by U.S. mail. I did a block mail, and that's what I did.
Okay.
In addition to whether if you want to email or text, a little off topic. One of the things that I have experienced over the years of communication issues and my landlord-tenant disputes, I tell every single landlord, do not text. Do not use that as a form of communication, because it is often misapplied, misused, ineffective, and the number of times I've been in court where a tenant has said, well, he texted me that, and then they pull up the phone and it's out of context. It's out of, so just a general advice, if you can avoid it, no texting. Emailing is a lot more effective because you're actually mailing something. There's a lot more structure, and you can prove whether they got it and read it. Sorry.
No, I appreciate it, thank you.
When I talk to tenants, I also educate them verbal and text doesn't work in landlord-tenant world. It just won't work. It'll fall apart somewhere because they didn't hear what you said or didn't understand what you meant. I don't care. It's going to go sideways. So I always recommend a piece of paper, and for you, it should be a part of the file. On this date, you did this.
What system do you guys use?
Appfolio.
Okay, with Appfolio, you can scan, you can write the one letter, scan it, upload it, and you're good to go. So, and you can share, and then if they say, oh, well, you know, I didn't get it, because you're also emailing it through the system, it timestamps. Oh, yes, you did. This is when I sent it out to you. And oh, by the way, it is shared in your documents. So that's the best part about Appfolio. The other thing that you have to do by January 1, 2020, don't shoot the messenger. I'm just here to tell you, you may have to do rollbacks if you were already anticipating the rent increases. So we'll go over into that in a minute.
Meaning, I'm not quite sure what you mean on the rollback.
I have an example on that.
Okay.
So I'll go through this example, and if you have questions, we'll talk about it. So let's say, and oh, by the way, your rollbacks, they have to be rolled back to March 15th, 2019. So that means that whatever the rent was on March 15th, 2019, if you have increased rents more than 8.34%, you have to roll back to that date. So March 1, you're renting a property to the tenant at $1,000. You send them a notice, a 30-day notice that says, I'm going to increase your rent by $85 this month. So as of April 1, the rent goes up to $1,085 a month, $1,085. Now, because you've sent them that notice, that March 15th date takes into account that the rent is now at $1,085, which is 8.5%. Our cap and index, it says we can't be over 8.34%. So I'm going to keep coming back to that. A lot of property owners called either themselves or called up their property management companies and said, I want you to increase the rent. I'll admit, I was one of those property managers. Clients came in, I bought this property, rent is below market, we gotta hike up the rents. I know the rent control's coming into effect. Okay, we'll do that. We don't know what's gonna happen, but we do have this law that's impeding, that is gonna go into effect. But we'll go ahead and increase the rents. So July 1, we send out another notice that said, oh, by the way, we're going to increase your rent by $108. So now you're paying $11.93 a month. Come January 1, I have to roll back the rent to $10.83. And the next time that I can actually submit for a rent increase at 8.34% will not be until July 1, 2020. because I triggered that second date in July. Now, if your rent increase was less than 8.34%, your initial one, some people did like a $25 or a $30 rent increase, you may go back and increase it up to the cap rate. No more. Okay?
Oh, you can't.
It has to be, so you can't do a $25 rent increase and then say, oh, I'm going to do a $75 rent increase, because $75 is actually less than the 8.3. It has to cap at 8.34%. Is that clear?
Yeah.
Any questions on that?
This is just on existing tenants, this isn't?
This is on existing tenants, correct. So one of the nice things that the California Apartment Association was able to drive to our legislatures was the de-vacancy rent control, which I am going to talk about in a little bit. But any questions on this part? So really, 8.3%, or just make your life easy. I don't want to have to calculate 0.3%, a third of a percentage, what the rent is. Just stick with 8%. You should be fine. And quite honestly, this is my personal feeling. In our community, 8% seems to be a decent rent increase on an annual basis. Vacancy decontrol. There was Assemblymember Chan actually said, well, rent control is rent control. I don't care if the tenant stays there or moves out. If the rent is low and below market, we're going to keep it below the market. California Apartment Association stepped in and said, now wait a minute. If a tenant that has lived in a property for 10, 11, 12 years, they move out, we don't want to create a situation where we have landlords saying, I'm not going to invest in my property because I can't rent it any more than $400 or $500 because that's what the previous person was paying. I want to be able to invest in the property, bring the property to a current market demand look so that I can get market demand rates for it. So that was one of the nice things. But no previous tenant can stay in the property. Everybody moves out. No roommates, not one of these, well, 3 college roommates move in and 2 of them move out and one of them decides to move out, but they don't, so the landlord, no, everybody has to move out. The property, the lease has to be terminated. Possession has to be relinquished. You cannot have anyone staying in that property. Once everybody's out, then you can do the work on it and bring the property to the current rent on the market.
Is there a value of remodel you have to do?
No.
Okay.
No. You still go through your tenant disposition letter, and depending on when you had done the work on your property previously. For example, within the state of California, 3 years is considered the norm on paint jobs. Anything after more than 3 years, you can't charge back the tenant. So, if you want to paint the property or if you can touch it up, I've never seen paint that stays after 3 years where if you did a touch up that looks good. But you don't have to do anything
So if
more.
you've got property that's real undervalued on rent, can you evict that tenant and spend 50% of the value and then rent it for the current market?
I'm going to say no and then hold that thought.
Okay.
Hold that thought. Okay?
I'll acknowledge the word, I don't like the word evict. You want to terminate the tenancy, that's great. When you evict,
Can we terminate the
shimmer will fall over.
And to answer your question, may you terminate tenancy just to bring it up? No, and I will get to that.
I'm not just a tenant.
So what do you have to do right now in terms of your rent control? Make sure you have a new lease in place. Plain and simple. And you said car forms. Oh my God, I hate car forms. They have so many holes in them. A lot of people like them because they're standardized, they're great, but they have so many holes in them that I feel like they just leak water. They're not worth the paper they're printed. I would recommend you speak to an attorney and put your own leases together. That's what I've done. Paul and Alan Amy, they each review our leases every year. I give him a copy, he reviews it. After he's done with it, I ask Alan, can you review this? Spent the money, it's worth it. Because car forms, they just have way too many, they leave too many things unanswered, but that's my opinion. You have to have a new lease in place for your tenants. It has to be similar. You can't change the terms of the lease drastically, but get them to sign a new lease and make sure that you have the right language in there on whether the property is or is not under rent control. Give them the notice regarding the new law, and then some of the other things add in there, which CAR does not have these things. There are so many new laws, there are so many new addendums that your lease must have that a lot of people don't have. I will tell you, Violence Against Women's Act, that was a law that went into effect in 2015. Today, Section 8 housing, if you have Section 8 tenants that do not have that language in their lease and you go to evict them, guess what? Judge will throw it out of court. You're going to have to start it all over again. So there are a lot of language that has to be in the lease. The flood disclosure. This used to be something that you only got when you purchased real estate on the floodplains. Now you have to give the same disclosure to a tenant. You don't have to give them the report, but you have to give them the disclosure. So make sure that you write up a new lease and that you have everything, including the kitchen sink, in your leases. Our leases, when I first started in the business, it was only 13 pages. What are we, 30 pages now?
24.
24 pages.
You hold the record right now.
So
Liberty.
just, Liberty Property Management's got more?
No, they're at 24 as well.
They're at 24 as well. So make sure that your leases are as comprehensive as possible. Before I go into just cause eviction, this was the last point in the rent control that I wanted, or into the law that I want to talk about, which is anti-price gouging. Anti-price gouging is based on it's triggered by any emergency, state of emergency. Rent cannot be increased. Now, this has nothing to do with the rent control. I'm just talking about your single-family properties that are exempt or condominiums that are exempt. Anytime there is a state of emergency and the governor says, okay, Butte County, Paradise went up in flames, we have a state of emergency. Santa Rosa went up in flames, we have a state of emergency. Anytime you have a state of emergency, rent cannot be increased by more than 10%. And it does not mean that just the affected areas. It also means anywhere, essentially pretty much the whole state, anywhere where there's overflow is going to be impacted by that. When Paradise burnt down, I ended up getting a few tenants. We couldn't say, oh, wow, your house burnt down, welcome to Turlock. We're going to go ahead and charge you $1,800 for rent here. Previously, it was only about $1,500. So that's a big jump. You cannot charge more than that. And it's not limited to the areas of emergency. I'm not going to spend too much time on this because I do want to get into just cause. Questions on this? No? Okay. Now, just cause eviction, it prohibits the termination of a month-to-month tenancy based on a 30 or a 60-day notice. It used to be, I don't like my tenant. My tenant is just it's just a nuisance. This guy or this woman will not stop calling, or I have complaints against them every month. Well, if they'd been there less than a year, you serve them a 30-day notice and say, have a nice day. If they'd been there more than a year, you'd serve them a 60-day notice and say, you know what, why don't you find more appropriate housing for you? Or something that suits your needs better. Got to be careful with how you put that. You can no longer do that. You cannot terminate the tenancy with tenants based on a 30 or a 60-day notice. And you cannot say, I'm going to go ahead and not renew your lease anymore. So you've been on a 1-year fixed lease, I'm not going to renew it.
Is this on the single family jurisdiction too, or whatever?
I have a whole sheet on that, and I'll talk about it in just a second. So this is who is exempt from just cause eviction. So any single family, very similar to the rent control, any single family, any condominiums, or any property that does not have corporate ownership. So real estate investment trusts, there's quite a few of them. they fall under just cause. Any LLC that has a corporate membership, they fall under just cause. But, so no corporate membership. Any housing that's newer than 15 years old, we kept talking about that revolving 15 years. It shows up here under just cause again. And then any property that is occupied by an owner on one side of the duplex and they rent out the other one. Any housing that is shared type of housing, dormitories, hospitals, care facilities, or there are people that say, you know what, I'm going to rent out the bedroom in my house because to the traveling nurses. Those types of properties do not fall under just cause. Especially if they have a shared kitchen or bathroom.
What if you have like a real good reason for terminating the tenancy? Like, I just had one that had bed bugs so bad, I give them their notice for 90 days, and then we're just gonna demolish the house.
So if you're going to demolish the house, that's a different story.
Okay.
You can give them that notice.
So, I mean, what if they have so much dry rot around their toilet, we have to totally rebuild the place, and there's nowhere to even use a restroom.
Rebuilding it, it's not just cause.
No.
Demolishing it is.
Well, and you can use as just cause a violation of the lease agreement.
Yes.
And if the okay.
I'm going to get into all of that. There's a whole list of what is considered at fault and no fault evictions. Because under just cause, it's either the tenant is at fault or they are not at fault, and that's considered either at fault or no fault evictions. And I'll get into what is at fault, what is no fault. So I'll answer that question a little bit more in detail. So what is considered just cause tenancy? I mean, at what point is that triggered? Now, anyone that moves into a property, let's say a tenant moves into a property and they stay there 12 months. After 12 months, you can no longer terminate their tenancy. Then it becomes, you have to have a reason as to why you want to terminate their tenancy. Now, tenant 2 moves in at about 6 months down the line. Now, this is why I say it's very important to make sure that you have really good leases, and your leases say specifically no subletting. Because if they sublet, they are now in violation of their lease. That's why you want to make sure that that language is not in the lease, or is in the lease that does not allow subletting. Now, tenant 2 moves in, and you say, okay, fine, somebody gets married, something happens, or a parent moves in. So now you have a new tenant that's moving in. At any time where those 2 individuals are in there for 24 months, from the time that the new tenant moved in, then that's when it gets triggered. The just cause for that tenant gets triggered. It's not from the initial date of tenant 1 moving in. It's 24 months from the date of when the second tenant moves in. And any tenant that lives there continuously for 12 months. Yes, sir.
So I'm not quite understanding. I understand just cause they have to break the rules of the lease. They bring in pets into the house, they bring in a roommate. What if they've only lived there for 12 months? I mean, we're not going to do that. We're
Right.
not going to kick them out. But I mean, you could have them move without just cause before let's say that it gets to be the 9th month, and we serve them notice. Hey, when your lease is up, it's over with.
So long as it's before the 12 months.
Okay, and then if they get married, and so now there's 2 people living there rather than 1 person, and then as long as it's within 24 months. If we want them to move, which we never have in all my days,
Right.
The only reason why we want someone not to move is 1, they stop paying the rent, or 2, they're destroying the place or
Right.
breaking the rules. I mean,
So that's where this comes in, right? So these are the reasons why you can give them a notice of termination eviction. Now, this is where I'm going to play with the words, Mark, termination or eviction. They don't pay their rent. 3-day notice, pay or quit.
okay.
Easy, right? They are in violation of their lease. They brought in a pet. They brought in a roommate. Now, this is when the enforcement of the lease and having really good, clear language, which CAR does not in your leases, is paramount. You have to have solid leases. They create a nuisance. And it says quiet enjoyment. They are now a nuisance and they are violating the quiet enjoyment of their neighbors. They're committing waste. They're destroying the property. That's considered committing waste. You can give them a notice. They are refusing to renew their lease. Now, I said that as of January 1, you have to have new leases in place with your tenants that are the same as they were before with the new language. They're refusing to renew their lease. They are conducting criminal activity. Now, state of California, marijuana is legal. So long as you have 6 plants, you're good to go. But they have a grow house for they have 25 plants, 60 plants, 100 plants. That could be a criminal activity. But I have Mark that wants to say something about that.
I would say to landlords, and I know smoking can be an issue, whatever they're smoking. I recommend to other property managers, easier just go, no smoking.
Yep.
And that'll cover you for that gentleman there, right?
Yep. So we have it in our lease, no smoking policy. There is no smoking inside the home of any kind. Now I tell my tenants, you want to consume it as an edible? Go for it all day long. Can't smoke it.
Well, and you've got the federal law.
And then you have the federal law. And in our leases,
Federally,
right.
a controlled substance, which is why all the pot distribution places cash only, because they cannot take checks, they cannot use the credit system because it's all federally regulated. So everything's done in cash.
So that's why in your lease language, you say state or federal.
Right.
You have to specify. If you just say state, then or if you don't mention it, then you can go by state. But there are ways to get around that. Yes, sir.
You just stated that we have to have new leases in place by January 1st, or we have to have an amendment out to them by January 1st?
You have to have an amendment out, but you also have to write up a new lease with them with similar terms. But you can wait on that until August of next year.
Okay.
I'm saying don't wait till August.
I got 400 properties. I mean,
I get it.
it'll take a couple days.
Yeah, it's you have until August 1, 2020 to get all new leases on all of your tenants. But make sure you get your notices out by January 1. So criminal activity, refusing to give you access to the unit. We have tenants that say, oh no, you can't come into my house. Really? My lease says otherwise, and here's my 24-hour notice of entry. You've changed the locks, here's a notice to perform or quit. You now have to give me access into the property so I can change the locks and I have a key to the property. And oh, by the way, you're not performing, then you can serve them with a second notice after the 3-day to perform or quit that says quit. So this is where things change a little bit. Now you have a dual notification. I see you frowning. Let me get through my list.
Where do you get your forms? What do you use for forms? For the quit, the 3-day notice?
We have, yeah, we've had forms that we've written, and they've just kind of been tried and tested in court. And Paul
One of the
reviews.
that I put out there is for the agencies that I work with. Get them out now. Eviction's gone. So if you were to call and say, hey, I got a problem with my tenant, they're doing this, and they'll say, well, we can do a 3-day to quit, 3-day to perform or quit, 3-day to pay or quit, and they'll charge you just for that notice in the service of that notice.
So Chris Hurst is his name, Gone Eviction, and his phone number is 576-2526.
You also can
It's
go
on that
online
card.
and look at the California landlord tenant no-low press, and they have the forms
Yeah.
as well. You can find out pretty much anywhere. Just make sure it's state of California.
No Press, if you've never used it, is one of the best and more comprehensive resources, not just for landlord tenant, but almost anything under the law.
Right.
It's well written.
Yeah.
The forms are in the book, and I believe the forms are on what was that called? No Press.
Or
no.
NOLO. And then if you have an apartment complex, more than 16 units, where you have an on-site individual whose employment has been terminated and refuses to vacate, you can evict them. And finally, if they serve you a notice, if the tenant serves you a notice and you accept it in writing, which as property managers we do, right? You just tell them, yep, I'm in receipt of your notice, and you have the right to do a preliminary inspection. I will do your final inspection. Give us a call so we can reschedule a preliminary inspection. And if at that point you have acknowledged that you are in receipt of their 30-day notice and they don't move out, you can evict, okay? Now, there's the no fault cause for eviction. Now, this is kind of going back to, well, you know, I just really don't like you. It used to be good old days. I have no reason, just don't like you. You gotta go. Here's a 30 or a 60-day notice. Well, nowadays, you're gonna have to start paying them.
You're gonna have to what?
You have to pay the tenant to move out. You have to give them the appropriate notice, and then you have to pay them equivalent to 1 month's rent. Now, you have an option of either paying that to the tenant when you give them the notice, or before the last month's rent is due, you put it in writing that you will waive the last month's rent. Because if you pay them up front and say, you know what, here's your 60-day notice, and here's the money, get out, right? Chances are that tenant will take that 1 month's rent and not pay the following 2 months and then get out. Now you're out 3 months of money, right? So give them the 60-day notice, and then right before the last month that they are in the property, 15 days before that becomes due, send them a notice that says, I'm going to waive you your last month's rent.
So
But that's how you can get.
terminate a tenancy just because you don't like someone? Is that what you're saying?
Currently, yeah. Currently, you got 30 or 60.
30 or 60
But
days.
you have to pay them 1 month's worth of rent to have them move, which that would fit for your house that you have a lot of damage. Or,
I'd have to not like them.
Well, if you have a single-family home,
me too.
Guy, if you have a single-family home, it doesn't fall under this.
Okay.
So, so payment of 1 month's rent, and I'll go. We have a chart, and Mark has provided us. And then you waive the last month's rent, and then payment within 15 calendar days of termination. This is like if you don't want to give them that 1 month's rent up front, that 15 calendar days, just send them a notice that says before rent is due. So you can't wait until the first, and they come in and hand you the check. If they do that, you're already behind the 8 ball. They can, that nullifies the notice.
So with this rule, years down the road, if you're way under rent, under market, can you just give somebody notice and pay them to move out and then raise your rent to the market value?
Technically, yes.
Here's what you do to avoid that paying them anyway. 'Cause I know my experience with owners and landlords is like, what? Pay them?
Right.
Okay? So rather than pay them, you just become very, very scrupulous with your lease. Oh, look, you do have a dog, cat,
Right.
turtle. It says no pets. You're in violation. There you go.
And with that, there are reasons that why you can terminate, but that's at fault. The no fault ones, the reasons to terminate a lease under no fault is if the owner wants to move in. Okay? Now, owner means owner, spouse, children, and parents. That's it. It does not mean my cousin on my wife's side of the family, third person removed, married to Uncle Bob. That's not owner moving in.
See your mom and dad better not.
So it has to be owner move-in, and these are the reasons why you can't get them out. Owner move-in, the government says that, we're going to ban this property. So you can give them a notice. If you are demolishing,
Government's going to,
If they've red tagged.
if they've red tagged the building. So I know in Modesto there was a building that was red tagged, so that would have been one of those. So if the building is being demolished, or if you are going to be significantly changing the property. Now this goes back to your question earlier. Well, I'm just gonna, bathroom needs to be worked on.
Significant?
So that means, you're a 2-bedroom, 1-bath house, and you're gonna turn it into a 4-bedroom, 2-bath house.
Well, that's significant.
That's significant. So it has to be significant. It can't be, I'm gonna rip out the carpet and the countertops and the paint and, doll it up. It can't be that. It has to be a significant change to the property in order for that to happen. And you,
Permit to do construction reason.
you have to, yeah, right. But if you're saying, I'm going to change the roof, that's not significant because you're putting another roof on. So it's not necessarily permitted work. It's anything that's going to modify the property significantly. Okay?
What if it makes the house inhabitable during that period of time?
You put them up in another place and then have them come back and pay that same rent to you. It's unfortunate, but that's what's going to happen. So this is kind of a spreadsheet. Now, Mark was kind enough to do this for you guys. So this is on the rent cap basics as well as the just cause eviction. So it has all of the notes. If, then, what if, what about this, what about that? So that's something that Mark gave out.
And too, if you guys have questions and they get really, they never are black and white. During this 10 years, they're black and white. It gets really weird really fast, I can say that. Boys, I will tell them what I think, what the civil code is. I know how decent rules for the most part. That gentleman, or whoever does your evictions, he's your person, because he's gonna have to defend if you do it wrong. Think about it that way. If you screw it up, you go to court and the judge might go, start again. He's not gonna tell you why. He will. So it might behoove you to have that phone call conversation to play all the different, and there are different ways to go, right, Paul?
Oh, yeah.
Okay.
Yeah. I'm free, but you know, I'm not a lawyer.
So this is kind of like a recap of what falls under rent control and what doesn't. So any property that is newer than 15 years old, it doesn't fall under rent cap or just cause. Affordable housing doesn't fall under rent cap or rent control or just cause. Properties that are owned by real estate investment trusts, LLCs that have corporate memberships, they fall under both. Now, I will tell you, there's always a confusion. Well, I have a living trust, or my parents set up a trust. This does not apply to them. This is real estate investment trusts that actually buy, hundreds of acres, and they actually have a trust. 2-unit parcels. If an owner lives on one side and they are renting out the other side, they're exempt. It doesn't fall under them. Anything that is 3 units or more is pretty much under rent cap and rent control and just cause eviction. What do you need to do? Again, update your leases. You have to notify the tenants whether it's going to fall under just cause or it doesn't fall under just cause. You have to have that addendum in your leases. You have to notify them. So update your leases. You have to provide the notification by January 1, 2020. So your addendum, it has to be put in there. And then when it's a single family home that you're managing, you have to let them know that does not fall under rent control, and owner does have the right to come back and occupy. You have to have that language in there. That brings me to the end. Thank you so much for coming.
Thank you, and thank both of you gentlemen.
Thank you.